So, good afternoon, everybody, and welcome to the Hare Court Employment webinar. This is the first webinar of this term. Thank you, everybody, for joining us. We're going to be dealing with 3 topics, but before I go into the details of those specific topics, it gives me great pleasure to welcome 2 of my colleagues. We have with us here today Tom Poole and also Emily Moore, both with me at Hare Court in the employment team. Just a little bit about both of my colleagues. So Tom Poole has a broad employment law practice, also covering commercial aspects. He has very recently been in the One Blackfriars trial, which is, I think, to date, one of the longest remote trials that there has been. So he should be very familiar with this format of being online. Tom is also on the Attorney General's A panel, so he's definitely an A-team person. He takes part in some of the government's most high-profile and complex employment cases. So thank you very much, Tom, for being here this afternoon. I'm also joined by Emily Moore, who is one of the more junior people in our employment team, but she has a real interesting cross of work that she does. So she's also able to deal with cases where they intersect with employment, insolvency, and company matters, which is very pertinent at this time, as I'm sure a lot of you can appreciate. She has done a range of cases: unfair dismissal, unlawful deduction of wages, and she also has advised a client in the Caribbean on the contents of an employment contract. And whilst I realise it's slightly atypical, I will introduce myself. My name is Sara Ibrahim. I'm in the Hare Court team. I also, like Tom, do a range of work, including commercial work, and appear in the ET, the EAT, and the High Court. I'm on the panel of counsel for the Commission of Equality and Human Rights, and I was lucky enough to be reappointed in 2019. So now we've got those matters out of the way, I would ask those of you who are participating, if you do have the ability, to make sure you stay muted and you don't share your video through this webinar. Though what I would encourage those of you to do who do wish to participate, there is a chat box. If you have questions, please do fill them in. Otherwise, I certainly will have some questions for my colleagues to get that portion of the webinar started. But without any further delay, if we then address the topics we're going to be dealing with, there are 3 topics. These are all based on areas we think will be of particular assistance to you and your clients during this period. We will be looking at redundancy, first of all. That will be Emily Moore and myself. We will then have a talk from Tom Poole, who's going to be dealing with post-termination restrictions. And then Emily and I will talk you through the future of work and what we think may be some of the legal ramifications. Now, Emily, if you're ready, shall we start with the first slide for redundancy?
Yes, let's do that, Sara. Hi to everyone watching, and please bear with me a moment while I just share my screen. Okay, so you should all be able to see the first slide with the Hare Court logo. If there's anything wrong with my screen sharing, then I'm sure I will be notified. So it goes without saying that this is a very hot topic at the moment. Many employers have sadly had to make a lot of redundancies in recent months due to the pandemic, and this is a trend that we will likely see continuing despite the extension to the flexible furlough scheme, which we'll touch on in one of our slides. So I think Sara is going to kick us off by looking briefly at the statutory definition of redundancy.
Thank you, Emily. So when you're looking at redundancy, it's always good to start at the beginning. And by the beginning, I mean the statutory definition of redundancy. I've got that up on the slide there for those of you who want to be better or reacquainted with that definition. But mainly, Redundancy encompasses three types of situations, as you can see. That's business closure, workplace closure, and reduction of workforce. During this period, it's quite likely that you could see one or a combination of those things, where, for example, you may have certain stores or sites which are closed, or you may have a client who wishes to reduce the workforce to make sure that they remain viable. So the dismissal of an employee will be for the reason of redundancy if it is wholly or mainly attributable to one of those things.
Right, so moving on from the definition, I'm just going to say a few brief words on the economic overview. So this graph, I hope you can all see it clearly, was produced by the ONS as part of its November 2020 UK labour market overview. And according to this estimate, which was produced by the Labour Force Survey, redundancies increased, and that's the peak at the end, obviously, by a record 181,000 during the period of July to September 2020. So this estimate has measured the number of people aged 16 and over who were either made redundant or took voluntary redundancy in the 3 months before the Labour Force Survey conducted their interviews. It doesn't take into account planned redundancies, so it's just either redundancies that have been already made during that period or voluntary redundancies. And it's worth noting that this, viewers may have already heard this statistic, it's the largest increase since February to April 2009. So it really is an astronomical rise. So Sara is now going to say a few words on the impact of the extension of the furlough scheme on redundancy plans. Over to you, Sara.
Emily, thank you. Now, a lot of people will have thought the extension of the furlough scheme, which was initially resisted by Rishi Sunak until he was forced into this U-turn, and to extend it until March 2021 was going to mean that a lot of job losses would not in fact go ahead. However, I've put some examples on this slide because I think it's important to know what the economic climate is and the kinds of companies and organisations that are being affected. So you will note with a lot of these examples that there are particular sectors which have been very badly affected by lockdown and have had quite bad cash flow issues. So starting with Whitbread, which has been in the press even today, and that includes the Premier Inn and Beefeater chains. They had a consultation that ended just last week. And whilst they were, before Rishi Sunak's extension of furlough, thinking of about 6,000 redundancies or job losses, this is now being reduced quite significantly. However, it's important with Whitbread to note this was not as a result of the furlough scheme, but because they are expecting the benefits, if you like, of their restructure. So that is redeployment and greater flexibility in working hours to actually mean that their initial figure of 6,000 isn't one that they're going to have to meet. Similarly, John Lewis partnership has been very much in the news. Now, the figure I've put there on the slide is in addition to about 1,400 jobs that they had already shed as a result of this pandemic. So it just gives you an idea of the real scale of this. So John Lewis have actually announced that those with 2 years service, they're actually going to be given an additional sum of £3,000 for retraining purposes. Greggs, which is seen as a real stalwart now of the high street, particularly with their vegan sausage rolls, have also been affected quite badly by the pandemic. So this weekend, that figure I've put of 800 has actually increased to 820 jobs that are going to be lost due to trading conditions during this COVID period. And again, they're saying that the furlough scheme and the extension hasn't really made a difference. Finally, looking at WH Smith, again, somebody will know this has been a real presence on the high street for a period of time. That figure, I think, is quite shocking. So the jobs that were announced that they were going to lose till the end of August represented some 15% of the workforce, and we're looking at a reported loss for WH Smith of 280 million in terms of loss profits. So we're expecting more jobs to go. So thank you, Emily. I think you're going to look at collective redundancy.
Yes, that's right. So I'm going to say a few brief words on this. So as people will probably know, collective redundancy notification obligations are triggered when an employer is proposing to make at least 20 employees redundant at an establishment within a 90-day period. And the notification and consultation obligations are set out in the Trade Union and Labour Relations Consolidation Act 92, which I'll refer to from now on as TOLRA. So who must be notified? So as set out in the bullet points there, the first group of people that have to be notified is clearly the appropriate representatives of the affected employees, and that's under section 188(1) of TOLRA. So if there's a recognised trade union, then it's going to be representatives of that trade union, clearly. If there isn't a recognised trade union, though, then it's going to be employee representatives that need to be notified. So then we come to the consideration of elections and in particular the requirements of section 188 and 188A of TOLRA. So these elections, they have to be fair. So that means that any candidates are from the pool of affected employees, and no person is unreasonably excluded from election or from voting. Now, if there are employee representatives who have previously been appointed for other reasons, so not dismissal-related reasons, then employers are going to need to consider whether they have the authority to be consulted about dismissals and receive relevant information in that regard. Even if there are existing employee representatives, employers might want to consult representatives who are elected specifically for the purpose of collective consultation, for reasons firstly of legitimacy, and secondly to ensure that the consultation has the confidence of the affected workforce. So moving on to the fourth bullet point, the insolvency service also needs to be notified by filling out the HR1 form. And the insolvency service collates information on behalf of the Department for Business, Energy and Industrial Strategy. And the form basically requires the employer to confirm that they're undertaking the redundancy exercise in a legally compliant way, so including on consultation and giving reasonable notice, and they need to provide any explanations for any failure to provide appropriate notice in that form. The HR1 notification has to be given at least 30 days before the first dismissal, where between 20 and 99 redundancies are being made, and where 100 or more redundancies are being made, it needs to be 45 days in advance rather than 30 days. And it's worth noting, of course, that a failure to notify the Department for Business, Energy and Industrial Strategy may lead to a fine. And that fine is now unlimited. It used to be capped at £5,000. And this is obviously separate from any claims that may be brought by trade unions or employees who are dismissed as redundant. So moving on, Sara, you're going to address collective redundancy and consultation, I believe.
That's right, Emily. Emily's already touched upon consultation, and consultation is an important component of collective redundancy. Why? Because under section 188 subsection 4, you must provide as an employer the employee's representatives with prescribed information. So what is that prescribed information? That's the number of proposed dismissals, the number and description of employees who may be dismissed as redundant, and the total number of employees of such description employed at the establishment. Now, employers must then consult with representatives. This is important with a view to reaching agreement, not reaching agreement itself, but at least attempting to do this. So proactive effort must be taken to try and get agreement. Now, this means, for example, the exercise must include discussions about ways of avoiding dismissals, reducing the number of people who may need to be dismissed, and mitigating the consequences of any dismissals. Now, in practice, this means entering into consultation with an open mind. So you have to be ready to listen and discuss counter proposals that may be put forward by the employees or their representatives. And you certainly shouldn't be going into consultations already knowing what the outcome's going to be. Now, I flagged up the issue in the case of Mugford, which is just because you have a collective consultation does not mean that you can avoid individual consultation. Now, what does that mean? So if on a collective consultation that you have agreed, say, criteria, selection criteria, that doesn't mean you don't have to discuss with individuals how that may apply to them, or suitable alternative employment. And finally, I just want to touch on a joint statement you may have seen from the triumvirate of ACAS, TUC and CBI, so a very unusual kind of working together in this way, talking about how redundancy should be handled. And they did identify 5 principles or criteria. The first is openness, the second is to be thorough, 3, genuine consultation, and I just remarked that's echoed in case law. The 4th is fairness, and the 5th, which I find particularly interesting, is dignity. So that is how you deliver the news to the affected employees. Now, ACAS had previously been reporting there was quite flagrant breach of some of these collective redundancy exercises. And that has included firing people with a day's notice and using messaging apps like text or WhatsApp. Now I'm going to hand back to Emily, who's going to touch upon voluntary redundancies.
Thanks, Sara. So first point to make is it's common for employers to seek voluntary redundancies. And a question that commonly arises is, should these be counted for the purpose of deciding if 20 or more employees are to be made redundant? So if that threshold for collective consultation is met. So firstly, there's the decision in Optari Group and Transport and General Workers Union, which is a decision of the EAT from 2007. And in brief, that case established that where an employer had made 20 employees redundant, and 3 of whom had applied for voluntary redundancy. And the latter, so those who had applied for voluntary redundancy, despite volunteering, had still been dismissed so as to trigger the statutory obligation to consult in section 188 of TOLRA. So what about situations where there's mutual agreement to terminate between the employer and the employee? And there we have the decision of the University of Liverpool and Humber and Birch, which is a Court of Appeal decision. And it was held in that case that termination of employment by mutual consent in such a way as not to involve a dismissal is not a statutory redundancy. And just briefly, Lord Justice Ackner said, I think these remarks are particularly helpful. I put to her the simple example of an employer who envisages sometime in the future, for example, because of new technology, the need to slim down his workforce, and makes an offer to those who are prepared to resign rather than wait to volunteer for redundancy, and supports that offer with a financial inducement which is far in excess of that which is likely to be obtained under the redundancy legislation. It seems to me clear that in that situation, assuming no coercion of any kind, that if that offer is accepted, there can be no question of there having been a dismissal. So that's a different scenario there. And finally, on this point, why is it important to advise clients about whether the duty under section 188 is engaged? Well, obviously, there's the protective award, and guidance on that was given in the case of GMB and Susie Radin Limited. So the protective award can be up to 90 days gross pay per affected employee, and it depends on the level of compliance with the consultation requirements by the employer. So this case, GMB, established that essentially where there's been no consultation at all, the tribunal is entitled to start with the maximum protected period as a starting point and see if there are any circumstances for justifying a reduction. So in this particular case, there'd been no meaningful consultation at all. So the tribunal was justified in awarding the full amount. So the tribunal emphasised that the purpose of the protected award is not to compensate claimants. It's actually to act as essentially a sanction. That's the word I was looking for, a sanction against non-compliance by the employers. So moving on, Sara, you're going to say a few words on redundancy and unfair dismissal.
And Emily, I am going to restrain myself saying a few words because those who are looking at this slide will probably recognise those two cases. Williams and Compare, Maxim and Polke are very well trodden cases, and in this ever-changing employment sphere, it's quite important to know some things are still good law. Just touching on the case of Williams, so that sets out some very useful criteria, which, even though they are not principles of law, have been adopted by both employment tribunals and at EAT level as a kind of good standard of fairness that employers are expected to adhere to. So some of those standards include seeking to establish fair selection criteria. That's often a key one. If you're dealing either with employers or employees, you will see things, for example, like grids and the use of more than one selection criteria to meet that test in Williams and Compare, and also to ensure that selections are made fairly and that there is an offer or offers of suitable alternative employment if that is possible. Polke is predominantly concerned with procedural fairness, and it is an important case because if your consultation did not run as it should, the tribunal can limit the compensatory award for the period it would have taken to run a proper consultation. The sting in the tail is that if the tribunal finds there could have been suitable alternative employment and that the employee was likely to have taken it, that it is going to significantly increase the award. I'm just going to hand back now to Emily to deal with selection pools and talk more about suitable alternative employment.
That's right, Sara, and this is our last slide on this topic, and before we hand over to Tom. So a failure to consider what the appropriate pool of employees for redundancy selection should be is likely to be unfair. And I've just put up there the case citation for Taymac Limited and Ryan, which was an EAT decision where it was decided that on the basis of redundancy being found unfair, it was because essentially the employers had not applied their mind to a pool, and therefore there was no meaningful consultation as to who was in the pool, with whom comparisons should be made with the employee's position and as to who should be selected. So can you have a pool of just one? I've put up there two cases. So the first, Halpin, essentially says that yes, you can. But apologies, I've got the order wrong. Essentially, that case said that Mr. Halpin had been posted from the UK to China before his employer decided to outsource its Chinese operations. So as a result of the outsourcing, Mr. Halpin was made redundant, and it was obvious that he was the pool of one because he was the only employee working in China. So in that case, it was possible to have a pool of one. However, employers should beware, and the case of Capita, Hartshead and Bayard makes that point clear, because essentially the tribunal is quick to point out that whilst you can have a pool of one, it's not without its risks, because often pools of one are used by employers as a method to target individual employees. So in that case, the employee was an actuary who was the only person in the pool. And the EAT essentially upheld the tribunal's decision that the employer was found to have acted unfairly in not including other actuaries in the pool. And the material considerations were essentially the fact that other actuaries did similar work to him, and that the work of the individual concerned wasn't actually being criticised. So in that case, you weren't able to have a pool of one. And then very briefly, the factors for identifying a pool. So whether the work is ceasing or diminishing, whether roles are interchangeable, and whether the employer has genuinely applied its mind to the pool. And then the duty to look for alternative employment, and what sort of a search needs to be conducted for an alternative employment. Well, essentially, you're not obliged to create work where it doesn't exist. However, employers do need to make a thorough search for alternative employment and document that search. And that will enable them to essentially show the steps that their business has taken if they need to produce evidence in defence of an unfair dismissal claim. And they should also make sure that their business continues to search for possible alternative employment until the date of an employee's dismissal actually takes effect. And then the final bullet point there is on the question of whether employers can hold a competitive interview process. And the case there, Morgan and Welsh Rugby Union, essentially says that you can hold a competitive interview process. So the Williams criteria are unlikely to be useful in a situation where an employer is appointing somebody to a new role after, for example, a reorganisation, because its decision is likely to be centred on an assessment of an individual's ability to perform the new role. So the tribunal essentially understands that the process is going to be more akin to an interview. So they're entitled to consider how that process was objective, but also it recognises that the decision as to whether a candidate can perform well in that new role will involve a substantial subjective element as well. So that concludes that slide, and indeed this segment on redundancy. Apologise, it was rather rushed at the end, but we've got a few more segments to get onto. So I'm going to stop sharing my screen and pass over to Tom Poole.
So Tom, I hope that you are ready to share your screen.
Hopefully, everyone will now see what I can see, which is the first of my slides. And thank you, first of all, Sara, thank you, Emily, and good afternoon, everyone. Perhaps unsurprisingly this year, I've increasingly found myself advising employers and employees on post-termination restrictions, or restrictive covenants in old money. Now, when I talk about post-termination restrictions, I'm talking about the types of restrictive covenant that all employment lawyers are familiar with, namely covenants dealing with non-solicitation, non-poaching, non-competing, and confidentiality. I therefore thought it'd be useful to spend my time this afternoon providing something of a refresher course on restrictive covenants, focusing on the court's approach and enforcement. Now, when advising clients on the enforceabilities of post-termination restraints, you should always have in mind, I think, a framework comprising the elements which a court will consider in reaching its decision. Now, the challenge, as I'm sure everyone looking at this and listening to me, is to identify those cases which will provide the most assistance from the huge number of restrictive covenant cases out there, remembering also that the enforceability of PTRs depends on the many facts and circumstances of each individual case. Now, it's often said that the definitive statement on the applicable principles is the judgment of Sir Christopher Slade in the Office Angels case. And I would certainly recommend anyone that's looking for an introduction to the enforcement of restrictive covenants to read that judgment at paragraphs 21 to 25. Drawing on what was said by the Court of Appeal in the Office Angels case, and also the later Court of Appeal judgment Coppage, which is on the slide, and also leading practitioner texts such as Paul Goulding's book on employee competition, it is possible to identify 6 stages to the court's overall approach to enforcing restrictive covenants: incorporation, repudiation, construction, legitimate interests, reasonableness, and lastly, discretion. And I'm going to try and say a little bit about each stage this afternoon. So we start with incorporation, a rather obvious starting point. As is set out on the slide, to be legally binding on an employee, a restrictive covenant must form a contractual term. So there must be offer, acceptance, consideration, and contractual intention. The most common problems arise because the approach to contractual documentation is not clear and complete before employment starts. So, for example, an employee starts before signing a contract of employment, or the contract is executed, but other contractual documentation is not provided until a later date. Or contractual documentation is provided, such as a staff handbook, but it is not signed for by the employee, or is only made available for the employee to consult. So the best advice, and the rather obvious advice, is to ensure that an employee signs a contract before starting work, but moreover, to ensure that that contract contains all of the restrictive covenants set out in full. So the next stage is repudiation. It's a general principle of contract law that if an employer terminates an employee's contract in breach of its terms, so for example, without giving notice, the employee is free from any terms of the contract that are intended to survive termination, so including post-termination restrictions. And that's sometimes referred to as the general bill posting rule after the case of general bill posting and Atkinson. Now, the reason I've included repudiation at this second stage is if an employee is free of post-termination restrictions because of an employer's repudiatory breach, it's unnecessary to consider whether they are otherwise enforceable. It is, however, worth noting in passing that the courts closely scrutinise what are called convenient instances of alleged constructive dismissal. We can see this sentiment being clearly expressed in the passage on the slide, which is an extract from the judgment of Mr. Justice Jack in Tullett Prebon and BGC Brokers LP. We now move to the third of our 6 stages, construction. So assuming a post-termination restraint has been properly incorporated and has survived termination, the next stage is to decide what it means. In construing a post-termination restraint, the court is engaged in the same exercise as when it construes any other term of a contract. So the court's aim is to discover the real meaning of the term in question. Now, one of the problems frequently encountered, unfortunately for lawyers, in construing restrictive covenants is the result of defective drafting. Some common examples: a post-termination restriction is imprecise. So, for example, the business in which the employee is restricted from working is insufficiently defined. Another example, the post-termination restraint is too wide. So, for example, the post-termination restraint is worded so as to prevent the employee from working in a way that would not harm the employer's legitimate interests. And third, the post-termination restraint is too vague or too uncertain. So, for example, if you drafted a post-termination restraint to restrain an employee, quote, so far as the law allows, unquote, that would be too vague to be enforceable. Now, I can't leave the topic of construction without saying something quickly about the case of Tillman and Egon Zehnder. Now, as everyone listening will know, Tillman was decided in the Supreme Court last July. And Tillman is notable for a number of reasons, not least because it's the first case on restrictive covenants that has reached the UK's highest appeal court for over a century. The most important aspect for today's purposes of the judgment is its impact on the principles regarding severance. And the first point to note is that parts of a single covenant can now be severed. Now, the traditional approach to severance, following the case of Atwood, which is summarised on the slide, was that constituent parts of a single covenant could not be severed. And as I go on to explain on the slide, and I won't read out the extracts from the Court of Appeal judgment in Atwood, But following Tillman in the Supreme Court, Atwood is no longer the law, and parts of a single covenant can now be severed. As we can see, Lord Wilson revisited Atwood. He considered it proved instantly controversial and ultimately unsatisfactory. So Tillman is no longer the law. The second point to note is the new major change test. So in assessing the test for severance, the Supreme Court applied a three-stage test. First, the unenforceable provision must be capable of being removed without the necessity of adding to or modifying the wording of what remains. Lord Wilson noted that that test, as you'll know it, the blue pencil test, has operated capriciously, but nevertheless, severance could only take place where words were cut, not extended or added in. Second, the remaining terms must continue to be supported by adequate consideration. Now, this requirement has rarely been material in the case law, and the Supreme Court considered that in the usual situation, this requirement can effectively be ignored. Third, removal of the provisional wording must not generate any major change in the overall effect of the post-termination restraints in the contract. Now, as a result of Tillman, severance is likely to assume a much more important role than it has previously. Having said that, Tillman should not be seen as all one-way traffic. The Supreme Court has suggested that there may be a cost-based sting in the tail for employers who draft wide clauses with the hope of relying on severance. So where, for example, the Tillman test is met, the court may require the employer to meet any costs attributable to severability arguments. So we move on to stage 4 of our 6 stages. Legitimate interests. Once the true meaning of the covenant has been ascertained, the court will consider whether the employer has demonstrated that it has legitimate business interests which merit protection by a restrictive covenant. The list of available legitimate business interests is not closed, but usually invoked are confidentiality of information. That's fairly uncontroversial. All contracts of employment will generally contain a provision restricting the use and disclosure of confidential information, as there's obviously a legitimate interest to be protected there. Trade connections, again, uncontroversial. And what we mean here by trade connections are relationships with customers, relationships with clients, suppliers, all of which create goodwill and can be legitimately protected. And then finally, stability of the employer's workforce. There is obviously value in a stable workforce, particularly when dealing with small or medium-sized enterprises where, for example, 2 to 3 employees leaving might constitute half of the entire workforce. So my tip here is to take time carefully defining legitimate business interests or interests in the contract of employment itself. And I often do this by way of a preamble to setting out the specific post-termination restraints in the contract. So stage 5, reasonableness. The starting point is that contracts that restrain trade are unenforceable unless they are reasonable. What is reasonable depends upon the relationship between the needs of the employer and the extent of the restriction the covenant imposes. As the concept of reasonableness is flexible, it would be impossible to draw up an exhaustive list of factors which will establish the reasonableness or unreasonableness of a specific covenant in a specific context. In my experience, the following factors will generally be relevant. The nature and definition of the business covered by the restraint. So, for example, the court will consider whether it is the sort of business which has localized custom and whether the restraint offers effective protection. The geographical extent of the business and the geographical extent of the restraint. In short, the wider the geographical extent, the more difficult the restraint will be to justify. Courts will, however, take into account the nature of the area in question. For example, a half-mile exclusion radius in my hometown in rural Devon will be easier to justify than a half-mile exclusion radius in the City of London. The duration of the restraint. So things to think about here would be how long until an employee's replacement is up to speed and has cemented relationships with customers? How long before a customer list or price list is out of date? How long before confidential information is no longer of value? Length of notice period. Think about whether the notice period is short, but the duration of the covenant is long. Pose the question, does the restraint relate to business the employee had been engaged at the time of termination? So, for example, imposing a restriction in respect of an activity in which the employee had no recent involvement is very likely to be regarded as unreasonable. And then finally, consider whether a less extensive form of restraint would afford the employer adequate protection. We move then to the sixth and final stage of the court's assessment, discretion. And the short point here is that the court has a discretion whether to grant an injunction to enforce the covenant. And when exercising its discretion, the court will take account of a whole range of factors, including the nature and extent of any actual or threatened breach. And the principle is succinctly summarised in the quote on the slide, which is taken from the judgment of Mrs. Justice Cox in the well-known TFS derivatives case. She said, even if the covenant is held to be reasonable, the court will then finally decide whether, as a matter of discretion, the injunctive relief sought should, in all the circumstances, be granted, having regard, amongst other things, to its reasonableness as at the time of trial. So I hope you found that useful. It was rather a whistle-stop tour, but hopefully identifies some points that you can take away and will be of assistance the next time you have a client with a restrictive covenant issue. I'll now do my best to stop screen sharing and hand back to Sara and Emily.
Thank you very much for that, Tom. And now we're going to bring you our segment on working from home and the legal ramifications associated with that. So I'm going to share my screen again. And Sara, I think you're going to introduce this segment for us.
That's right. Thank you very much, Emily, and to Tom for that very interesting talk. So after a quite grueling 2020, I think we all decided it would be good to end by looking at the future. What is in store for the future of work and beyond? Now, a lot of you will know that the pandemic has very much accelerated a trend that was already in motion, and that is working from home. Most of you today will be working from home. I just wanted to take you through this very interesting study that was released in August 2020. You can see that in 2019, so that's before the pandemic and lockdowns, you had just under 5% of the workforce in the UK working from home. And that rose at the very height of lockdown to just under 45%. The really key point here is 9 out of 10 employees who've worked at home during the lockdown would like to continue working at home. And just under half of those want to work at home often or all of the time. So this home working revolution, as some people have called it, is very likely to stay. That being said, it would be remiss if I didn't mention this trend has been far more pronounced in London and the South East, and amongst those with higher qualifications and those in managerial roles. If I could hand over now to Emily.
Sure, Sara. So I was just going to mention briefly that some tech companies are already preparing for an office where most employees will be working on a hybrid system. And Google conducted a poll recently where over 62% of the workforce who were polled said that they wanted to work part-time from home going forward. So I think that's quite illustrative. And so although working from home is hardly a new concept, it's fair to say that the scale on which it's been embraced over the last sort of 9 months or so is really significant. So one of the key legal implications is human rights related, and that is the compatibility of working from home with the Article 8 respect for private and family life. So clearly home working represents a blurring of boundaries between the public and the private. And this had already commenced with the widespread use of mobile devices, allowing and encouraging working outside of traditional hours. And this has only been accelerated by the pandemic. So clearly the trend for video conferencing facilities such as Zoom and Microsoft Teams means that colleagues and clients have an unprecedented window into a person's home. So whilst on one level this can appear quite frivolous, with debates about an individual's bookshelf or interior design, on the other hand, it can quickly become quite intrusive, as members of the household, for example, partners or children, can be seen or heard. And that in itself throws up a number of human rights implications regarding the right to privacy. So Sara, I think you're going to tell us about the case of Barbulescu.
Yes, that's right, Emily. So this is a case of the European Court of Human Rights. And for those of you who have been slightly confused by certain Conservative MPs' commentary, we will be remaining a signatory of this particular court after Brexit. So this case law is going to remain very important. Now, in Barbulescu, you had an employee who had seen from central office a notice about how the head office was going to start monitoring internet, phone, and if you remember it, fax, if it was used for personal matters during work hours. Mr. Barbulescu set up a Yahoo private messenger account. He was the only person who had access to this, the only one who had the password. And even though he was using it to liaise with some of his business contacts, he was also using it to exchange messages with his fiancée and family members that the court commented were intimate. Now, despite the fact he had signed this policy document, the court actually did go on to say that the employer's restrictive regulations left the applicant with a reasonable expectation of privacy. Be that as it may, an employer's instructions cannot reduce private social life in the workplace to zero. Respect for private life and for the privacy of correspondence continues to exist, even if these may be restricted insofar as necessary. And that's at paragraph 80 of the judgment. You'll see on the slides that there are 6 key principles that were set out by the court in Barbulescu. The important one being prior notification of any monitoring. And it is also important that when any employer is looking at monitoring, that isn't to be any more intrusive than is necessary. And Emily's just going to take you into another case of the court.
Yes, I'm going to talk briefly about, as Sara says, another European Court of Human Rights case called Lopez, Rebalda and Spain. And this looked at the issue of consent. And very briefly, the facts are summarised there on the slide. So essentially, supermarket cashiers were visibly and covertly monitored by CCTV cameras, but were only notified about the visible cameras. So the applicants were filmed by the covert cameras taking part in the theft of the employer supermarket's goods. And the Grand Chamber considered the 6 principles established in Barbulescu, but found no violation of Article 8, accepting the findings of the lower national courts that the covert surveillance was a necessary employer decision due to the extent of the losses and the number of employees participating in the theft. And just a few brief points to pick up on from the judgment. So the court recognised, this is at paragraph 122, that the employer's interest in ensuring the smooth running of the company by exercising its management powers was a significant consideration. The court also considered the relevance of where an employee's duties were performed. So in this particular case, it was a place that was open to the public and involved permanent contact with customers. The court also commented that the expectation of privacy is very high in places which are private by nature, such as toilets or cloakrooms, where heightened protection or even a complete ban on video surveillance is justified. But on the other hand, that expectation of privacy is much lower in places that are visible or accessible to colleagues, or, as in the case of Lopez, to the general public. The court also considered the duration of the surveillance. So in this case, it was 10 days, and it ended after the responsible employees had been identified. And despite the use by the employer of the video evidence to dismiss, this was actually held to be appropriate, as it was only used for that specific purpose and it wasn't put into the public domain. Just give me a moment while I change slides. So Sara, I think you were going to say a few words on the consideration of these issues in the UK context.
That's right, Emily, and I wanted to start with the case of McGowan and Scottish Water. Now, in McGowan, Mr. McGowan was accused of falsifying his timesheets. So his employer decided to engage private investigators who were going to observe him from the opposite side of the road. Just so you're aware, this is the opposite side of the road from his home. He was then dismissed because the private investigator was able to find that the suspicions were correct. Interestingly, the tribunal determined surveillance was justified under Article 8.2 because it was in the interest of public safety. Namely, Mr. McGowan worked in water safety. And the Employment Appeal Tribunal, when they heard this matter, emphasised there was a legitimate expectation of employers to monitor their staff. Now, I think it's particularly interesting what the EAT said, because they didn't engage perhaps in the same way as the European Court of Human Rights. They went to say in their judgment, the position is therefore that by alleged conduct on the part of the appellant, namely the issue of false timesheets, the respondent is forced into action to investigate the matter. It is not the case where surveillance was simply undertaken for external or whimsical reasons. In our view, it goes to the essence of the obligations and indeed rights of the employer to protect their assets. Looking at the matter this way, it therefore seems to us that it is not disproportionate, and accordingly the findings of the tribunal that the article was not breached can be supported on this basis. It has to be borne in mind that the suspicions of the employer were found to be established, and the subsequent disciplinary process, which is not challenged as a matter of fairness, resulted in the appellant being dismissed on grounds of dishonesty, a very important aspect of the case. So I just remark there that they seem to find that because they were right that Mr. McGowan wasn't acting honestly, that the surveillance was proper. That leaves an awful lot of employers potentially in a muddle as to whether they should embark on surveillance or not. I think, Emily, you've got a question that's been posed by this Scottish case.
Yes, so very briefly, the facts of this case were as follows: that the petitioners were 10 police constables, and misconduct proceedings had been brought against them following the discovery of messages contained in private WhatsApp group chats. So the petitioners sought declarations that the use of their private correspondence to found misconduct proceedings was unlawful and a breach of their Article 8 rights. And the court held that no, it did not breach their Article 8 rights, because the employees could have no reasonable expectation of privacy in respect of the WhatsApp messages in question, and there was therefore no interference with their Article 8 rights. So the court at first instance was held to have been entitled to take into account the content of the material, the status of the employees as police officers, and specifically that they were holders of a public office, which meant that they had accepted certain restrictions on their private life. So even though it was a quote unquote private WhatsApp group, they were found to have no reasonable expectation of privacy in that particular case.
Emily, I just wanted to touch upon the critique of the judiciary's current approach in this country. In a similar vein to the gig economy workers, academics have perhaps been slightly further ahead than the judiciary when it's looking at these issues and what they should be considering. So I've put a article on the slide there of Dr. Philippa Collins, and she very interestingly notes there is a chasm, as she puts it, between the UK statutory common law protections, and by that she means prioritisation of an employment contract. So we're looking at matters a lot of people will be familiar with: control, integration, a lack of economic risk. And this is a complete contrast to what the European Court of Human Rights does, where they focus on an individual and their complaint, and they put that right front and centre of any dispute. So there we have a very clear conflict, and that's a conflict which doesn't seem to have been worked through the case law, and certainly Barbalescu and the 6 principles there haven't been considered as of yet.
Thank you very much, Sara. And so this is our penultimate slide, and it's essentially an outline of some useful resources that you may want to look at when advising clients if any of these sort of issues crop up. So the first is the ILO's guidance on teleworking during the pandemic. And this includes some cautions against using surveillance and monitoring technology as a quick fix. Because as the guidance warns, this can lead to a reduction in trust in management and can also be associated with counterproductive behaviours, as well as obviously throwing up a host of ethical questions. Then we have the CIPD's research on employees' experience of home working during the pandemic that was published in July 2020. And just briefly highlighting some of the findings from that that are particularly interesting. So only 35% of employees and or their representatives had been consulted at all on the introduction or implementation of new technology in the workplace. 86% of employees believed that workplace monitoring and surveillance would increase in their workplace in the future, and 73% felt that introducing workplace monitoring would damage trust between workers and their employers. And then lastly, on a data protection note, the ICO has produced some very helpful guidance indicating that they will adopt, as we said there on the slide, a flexible approach when assessing their regulatory response to potential data breaches. So that's a whole other area. Sara and I have actually done a video on this, which is available through our LinkedIn and various other social media channels, because that is a separate and distinct area. But we thought it was worth mentioning that aside from the Article 8 and right to privacy issues, that data protection is a whole other field that needs to be considered. And Sara, I'll leave it to you to cover our last slide.
Thank you, Emily. With a lot of these articles or stories that I've touched upon, I just wanted to emphasise that whilst this may seem hypothetical and maybe away in the distance, the monitoring and the increased use of technology does mean that there is going to be an increasing conflict, that it is going to, I think, bear fruit in litigation. Just starting quickly with this article by this very gay New York Times journalist who actually, of his own volition, put one of these monitoring bits of technology on his home computer. To give you an idea of how that worked in practice, on one day where he did a 14-hour day, the technology told him and his boss, who he allowed access to this, that he had only been 22% productive. I'm sure we all feel slight terror at the notion of only being described as 22% productive on a 14-hour day. You'll also see closer to home, we have PwC, who've been using facial recognition tools, and also the Information Commissioner is already investigating Barclays for spying on their staff. So the story is still very much in development, but there is a conflict there. And as we have seen, where perhaps technology and innovation is outstripping either statute or case law, there does come a crunch, and we've seen that with gig economy workers, and Emily and I are quite strongly of the view that that is going to be coming when it comes to working from home. Well, that concludes all 3 segments. In a typically barristerial fashion, we filled almost entirely the whole time that we set, so I would apologise for that. However, there will be an opportunity to ask questions if you do wish. Though before those of you who need to go, given we are at 5:30, I would remind people you can, if you wish, ask for shares of these slides. You can email us at marketing@3harecourt.com. We'll happily provide them to you. For those of you who have colleagues who would like to see this and have been unable to, or if you would like to rewatch, we will also be circulating a copy of the recording. So I say that for those who need to leave at 5:30. Before we do leave, there is a question I have, and in fact I'm taking advantage of the fact that I can ask questions without needing to put my hand up or write anything into a text box. I wondered, Tom, if you're still there.
Yes.
Great. I was just wondering if you could answer in your very, very helpful talk. You took us through all of the steps, but not perhaps if COVID and the pandemic has had a particular impact on the subject matter you're talking about.
Well, I think the main impact that I've seen is employers increasingly being asked to waive post-termination restraints in light of COVID. I mean, there are obvious downsides, as everyone can work out for themselves. If an employer is considering redundancies, it's losing staff because it has to, not out of choice. And if then a former employee moves to a competitor and takes business with them, this is going to cause further damage to an employer already in a difficult place. I think, though, it is worth bearing in mind there can be unexpected advantages to leniency. So the fact an employer has acted well, particularly during a global crisis, will resonate, might be remembered. A willingness to compromise might well serve an employee's brand well in the long term. So my general advice is to try and seek a middle ground. So, I mean, just taking some of the well-known restrictive covenants, if an employee's contract contains, say, a non-dealing or non-solicitation restriction, and you as an employer waive the non-compete restriction, there's going to be a limit to what that former employee can achieve for a competitor, at least in terms of encroaching on your business, particularly if the contract also contains robust confidentiality provisions. And I would say the smoothest redundancy negotiations are aided by generosity. So the more generous a severance package, the more likely an employee is to agree to its terms. So perhaps if you've got a client, you're advising an employer with a tight budget, you might want to advise them to consider leniency on restrictive covenants. So, for example, offering to waive a non-compete restriction is likely to significantly improve the attractiveness of a redundancy package. So I think it's there. That's where COVID's had an impact. It's the requests to waive PTRs.
Tom, that's very helpful, and thank you very much for your very full answer. Perhaps as questions haven't quite come through, I have one point that Emily and I have been discussing. Emily, we were discussing where home may be for the purposes of home working. You may recollect that a lot of us have been talking about the figures about working from home and the number of people who are working from home. But we haven't in fact touched upon yet that quite a lot of those people may decide to go and work from home somewhere other than the UK. Emily, you had some comments on this.
Yes, Sara, so sort of anecdotal comments really. I've known quite a few people who, particularly during July and August, after the kind of travel corridors opened, decided to basically not take holiday, but just go abroad and take their work with them and work abroad for a bit and kind of take advantage of that flexibility. And also I've read in the press, I think it was Barbados, announced that they would, I don't know if they've actually followed through on this or will follow through on it, but they were thinking certainly about allowing people for a 1-year period to come and live and work in Barbados. So it's just quite an interesting proposition that now we may be able to not just work from home, but work from any location overseas. And Sara, I think you had quite a pertinent point about how that might interact with the ECR, the Article 8 obligations that we were discussing.
Well, absolutely, Emily, because the signatories, of which there are around 47, to the European Court of Human Rights include very diverse places. So not just mainland European countries, for example, Portugal or France, but places as diverse as Azerbaijan, perhaps not as attractive to go and work as Barbados, as you pointed out, but there are lots of countries that could be caught by the principles that we have been talking about. So it's important as an employer that perhaps you keep up to date with where your employee is actually working from, because home may come to mean very different things, even when we're past this COVID period. Well, given that we've been talking about Barbados and working in sunnier climes, I think I will leave us there on that happy note. And I just want to say thank you very much to my colleagues who've been very generous in sharing their time. Thank you, Emily, and thank you, Tom. And finally, as I said, if anyone does wish to get in contact with us, I know some of you have already interacted with us on LinkedIn and Twitter, but for anything else, please do email marketing@3harecourt.com and we will do our best to assist you. Thank you very much to all.